I'm not going to penalize you for being a bad father. Father the child, you had nothing to do with the child. That's bad. I can't stand that. I think any man that impregnates a woman, if you don't take responsibility for that child emotionally, financially, well, then you got a lot of answers to give yourself when you look in the mirror the next time. All right. Good morning.
Good morning, Judge. Attorney Thomas Courts. Here on behalf of the defendant, sir, please state your name for the record, please.
Good morning, I'm Jacob Douglas.
All right. So let me just recap here. He pled guilty to operating while impaired due to the consumption of drugs. He also pled guilty to failure to report a property damage accident. The original charge of operating while intoxicated due to the consumption of drugs or operating while with the presence of drugs was dismissed, and as was the leave the scene of a property damage accident. He also has an outstanding civil infraction in front of him that he did not pay dating back to 2023. I mean, it was the same date. They've got a different case number. It's just 7075B instead of, I'm not sure why they were not consecutive here, but at any rate. So I referred him for a screening and assessment. Have you had a chance to review the report with him, and are there any material additions, corrections, or deletions?
I have, Judge, while it was accurate at the time, there are two updates I'd like to share with the board.
Okay,
His employment status has changed. Instead of working at Arby's,
1 second, Amy. Okay, instead of working at Arby's part-time, he's what?
he's now working, doing gutters. He's now doing gutters at Gene's Construction Company.
Okay, I'll modify the report in that aspect.
And then, Judge, there's also, his 2-year-old child. The mother has lost her job, and so now he is providing assistance and help with.
Okay,
Besides that, Judge, we believe the report to be fully accurate.
all right. Anything you would like to say on his behalf?
Judge, thank you. The case is from 2023. That's not the behavior, but it is to say, Judge, that there's a slightly different person that stands in front of you. He came to court today. He's voluntarily trying to handle his legal matters. He's working, he's employed. He's got a child back in 2023. He didn't have a child. My client, this is a drug-related problem, and he's telling me that if we were to test him today, he'll test positive, Joe, which really changes the whole dynamic of the
He will test positive?
Oh, I'm positive. Sorry about that, Judge. He's positive that he would test clean.
I don't usually expect defendants to come up here and acknowledge that they've violated a bond condition, so I'm glad to hear that at least, but go ahead.
Thank you. So he's, so I would ask Judge that he be put on probation because the underlying drug problem wouldn't be treated.
What happened with his assault with intent to do great bodily harm less than murder probation violation out of the Third Circuit Court? Does he still have that outstanding?
He has that, Judge, but we are handling that. I am going to take on the case of Taylor where that violation came out of, and we are going to go in front of Judge Casca, preferably this week, and turn him in on a warrant. He wanted to come and take care of this, but we're going to take care of that warrant and tell the judge we're fighting that case, Judge.
Okay, why isn't he showing up on that? The date of that warrant was only June the 18th, but nonetheless, he received notice. Why didn't he show up?
Judge, I don't have a good explanation for that, but we can go there immediately. I'm going to circuit court right after this, Judge. If you'd like, I can take him with me and turn him in for his warrant.
Okay, go ahead.
Thank you. And that is all I'd like to say on my client's behalf at this time.
What are you doing? What are you doing? I don't know how many chances you think you're going to be given. I get the fact this is a first drug or drunk drive. I'm not looking at things in an isolated fashion like that. You got a big problem. Well, I'd like to believe you've changed, but it's hard for me to believe you've changed when you had assault with a dangerous weapon in 22. Granted, this is a 23 case. Then you were convicted of assault with intent to do great bodily harm and felonious assault. Another count of felonious assault in the Third Circuit. Then you had an aggravated assault out of the Third Circuit. So they must have pled that down from initial felony. Then you were arraigned on a charge. You have a case out of the 23rd District Court for malicious destruction of property. Now, that's just an arraignment. Maybe you weren't even there. It might not have been, it might have been somebody else. I don't know. Then you were arraigned on a charge of domestic violence out of the 23rd District Court on a charge of domestic violence, same date from the MDOP. Also arraigned on a charge of assault and battery out of the 23rd. Now, again, maybe you're innocent of all those. Maybe you were out of the country and somebody used your name. I have no clue. But you're not doing too good. You leave the scene of an accident here.
Understand. A lot of that stuff happened before I had a daughter. That was 2023. My daughter was born 2024.
Didn't happen before 23. The only thing that happened before
23,
this one and the felonious assault from 22 happened before you had your daughter born.
Yeah.
And it doesn't even sound like you spent a lot of time because, correct me if I'm wrong, this claims paternity to a 2-year-old daughter, but reports not paying any child support or being involved in the child's life. That's what you told probation. Is that true or is that a lie?
That's not true.
You told them you weren't involved in your child's life?
Well, at the time, I was working at Arby's and I had got a job.
Hang on a second. Let's slow down. You just started on this case on April the 20th, right?
Yes, sir.
You reported at the time of the screening, which was on June the 17th, which was only 2 weeks ago, right?
Yes, sir.
You reported all of this to the probation department,
Yes.
right? And now you're saying, well, my life changed when I had my daughter, even though you had the daughter in 24 and all these other events have happened in 25 and 26. And now you're making it sound like you changed in the last 2 weeks.
Well, a lot of those things, you know, the crime was committed in them years. I wasn't convicted until.
I don't want to hear anything about the charges. All I know is the probation department is recommending jail and I don't blame them. And I'm only talking to you because I'm trying to figure out how I can rationalize in my brain not sending you to jail.
Yes, sir.
Can I speak just that quickly, Judge?
Sure.
As this case relates, just as this focus case is about drugs, I would argue that this case would be better treated with probation. And those other instances, Judge, you're definitely, of course, right to take note of them. But he's gonna have to answer to Judge Casca, who specifically handled that case and that violation. And deal with the judges and Taylor for the underlying facts, Judge. So I would just ask for the mercy on this case to let him have probation. And if the facts of those other cases, when they're fully fleshed out, more in jail, I'm sure the circuit court will issue that.
Look at all these substances you had in your system. You had no business driving. No wonder you drove into a utility pole. It's a good thing you didn't hurt yourself or somebody else. Then you left the scene. Then you ignored the court. You didn't show up. You're lucky. You are really lucky. You know why you're lucky? I'm not going to take into account any of these new charges where there had not been convictions. That's not appropriate for a judge to do. I'm not going to do it. That's not appropriate. That's not the way our system works. or should work anyway. But you are going to be on a short leash with me. And I am going to trust, Mr. Quartz, that you are going to take him down. You said you were taking him down today?
Yeah, well, as long as he has no objection, you can ride with me and I'll take you down there right now.
Are you going down there? Because I'm going to order you to go.
Yes, sir.
And if you don't go, you're going to serve 93 days. And you tell Judge Kask I said that.
Yes, sir.
All I know is I don't like the way your life is going so far for you, not for me. But if you end up in poverty, it's no skin off my neck. You don't have a diploma. You don't have a GED. You're making $250 per week. Maybe this job's going to pay you more. You fathered a child. You had nothing to do with the child. That's bad. I can't stand that. I think any man that impregnates a woman, if you don't take responsibility for that child emotionally, financially, well, then you got a lot of answers to give yourself when you look in the mirror the next time. But I'm not going to penalize you for being a bad father. I'm not a social worker. I'm not a priest. You are on such a short leash with me, you have no idea. On the drug driving, the operating while impaired due to the consumption of drugs. This is the sentence of the court. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. By the way, do I have proof that he attended AA? NA? Did you show it to your lawyer?
I did not, but I do have.
Show it to him. I expect to see that you've gone twice per week since June the 17th. If there aren't at least 4 on there, I hope you brought your toothbrush.
Judge, just for full disclosure to the court, so far there's only one listed, but we'll get them there, Judge.
Okay? You're not taking it seriously then. And I don't want to hear any more. She talks cheap to me. Had you gone to AANA, I was not going to send you to jail. Now you lose.
Well,
Now you lose. I don't want to hear another word. I don't want to hear another word. I'm not going to listen. Tells me you don't take courts very seriously.
I appointed today to go to a meeting. I was actually.
Too late. Too late. Too late. Too late. 24 months probation, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're to submit to chemical testing, PBTs, and ETG tests. That'll be weekly for 3 months. If you are clean, it will then be bi-weekly for 2. If you are clean, it will then be monthly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to obtain and maintain employment and provide proof. You're to obtain a high school diploma or a GED. You're to attend AANA twice a week until you are in an outpatient substance abuse treatment program. Once you get in outpatient substance abuse treatment, you no longer have to attend AANA. You're also to attend the Victims Impact Panel. That is one night put on by Mothers Against Drunk Drivers. Defendant to surrender to the Wayne County Circuit Court for probation violation hearing on warrant entered on June 1826 within 2 business days of his release from jail. Now expect proof of that. You are to serve 12 days jail credit 1. You're going to serve 6 now, and you're going to serve 5 more days on the court work program pursuant to the probation order. There's a $35 a day charge for that for a total of $175. You're to pay fines of $300, costs $250, $75 victims' rights fee, $50 justice assessment, that's $675, screening fee $60 for $735, probation fees are $40 for $12.15 plus your court work program fees. The total's $13.90. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. On the failure to report a property damage accident, I'm simply going to go 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4, 5 days court work program. Court work program days concurrent with that I imposed on 25B147048A. I will simply go out of my way and give you credit for time served on the no proof of insurance. Defendant given credit for time served. On the no proof of insurance, Heather, but he still must pay the clearance fee. So you're still going to have to pay your $45 clearance fee. Now, he doesn't have any money today, does he?
I don't believe.
You don't have any money.
I have a few dollars on my job. And like I said, I've been working endless hours.
Okay, good. Do you have enough to pay the failure to report a property damage accident? That's 3 1/4. How
No,
much do you have?
I'm pretty sure I have like $100 on my job.
So you're sure you can pay 100 today or not? Just tell me the truth. I'm not going to penalize you anymore.
I think it's like $90 a month.
You pay $90 now on that. Then you're going to pay $30 per week on that case beginning on July the 31st. If you don't have the money, you call the court. We'll go on Zoom on or before the due date at 8:30, or you can come in and talk to me on or before the due date at 8:30. Then you're going to pay on the other case, the operating while impaired due to the consumption of drugs. You have a bond of $5,000, 10%. I'm pretty sure we can apply that with the 10% because he's not been discharged from obligations with the court. So you're going to pay $450 now on that and $30 weekly after fines costs paid on 7048B. You are in custody for the next 6 days. I'm not going to change my mind. Maybe next time you'll understand you're going to comply with my orders. If you don't, you're going to end up going back. It's time for you to grow up. You're 22. Get away from this criminal activity. Start acting like an adult. Good luck. Thanks, Mr. Court.
Thank you, Chris.
Jaroslav Siamonic, 265-415-32. Good morning. I hope I didn't scare you after that one. Your name?
Charles.
All right. Okay, you're going to plead impeding, right?
Yes.
Responsible or not responsible? Please accepted. Speeds dismissed. 170 is your total. You can go down the hall and take care of that, and you're all set. Good luck.
Okay.
Stephen Lee Miracle Jr., 25B148937. Morning, sir. Your name? All right. You are charged with larceny. You have the right to an attorney. I'd be happy to provide you with one at public expense if you would like. Okay, we'll give you a lawyer. You'll go out in the hallway and we will set you up with an attorney, okay?
Thank you, Your Honor.
You're welcome. Good morning.
Morning, Judge.
What are you here on?
Orator's Johnson, the sentencing, I'm ready for that.
Perfect. Or-
This one.
Orator Stanchion, or Oratorius Brandon Johnson, 26B150198A, and B and C.
GOP 8237, we have Mr. Johnson, station.
Altaris Johnson.
He's another one that gets himself in a lot of trouble, huh? I mean, these are suspend, I guess, just going back to 16, but what's he doing with opiates that weren't prescribed? I mean, he pled guilty. I'm not going to take it under 7411. He's got another case where he had one. I'm prohibited from doing that. He's got another drug conviction. I don't know if we covered that, but I'm not going to take that under 7411. It's good.
Never had any.
2014. I didn't say pills. I don't know what it was.
Yeah, it was marijuana.
Huh?
2014.
I can't do it. So if you want to go talk to the prosecutor again, you can. If you want to tell me, Judge, we'll just accept that as a plea as charged, that's fine. I will still honor the other charge, the resist and obstruct under 771.1 that he pled to. And that was back on, what day did I take that plea? What day did I take that plea? I wasn't very good with noting this, Heather. Heather, it looks like on June 17th. So I took that plea.
Yes, Judge, it was.
June 17th. And you can just tell me what he wants to do.
He wants to move forward with the sentencing.
So you acknowledge and understand that this conviction for possession of a controlled substance will go on your record, that I'm not going to take it under section 771, I'm sorry, section 7411. The conviction will immediately enter. It will be on your record, and it's not going under that statute, and I will sentence you on that case. Do you agree to that?
Yes.
And you acknowledge I need not take a plea again, counsel?
Yes, Judge.
All right, I'm just give me a second to make a note. Case not taken per 7411. Please make a note of that, Heather, because defendant had prior drug charge in 2014, prior drug conviction in 2014. So I'm just going to go ahead and sentence you anew on that. And with that, counsel, we have a plea as charged, possession of a controlled substance. We have a plea to resist, hinder, and obstruct an officer. And that's going to be taken under section 771.1. And then there was an expired plate charge that the prosecutor agreed to dismiss file C. So I'm only going to deal with files A and B. Have you had a chance to review the report with them, and are there any material additions, corrections, or deletions?
We have, Judge, there are no additions, deletions, or correction.
Anything that you would like to say on his behalf?
Yes, Your Honor, as the report said, he is employed, he has a couple of children. I would ask for the court, if the court is gonna order any days on that court work program, if the court would take into consideration that Mr. Johnson does work full-time. He does like to spend time with his kids on the weekends, so I would just ask if the court would take that into consideration. Other than that, Your Honor, we would ask if the court would adopt probation's recommendation.
Anything that you would like to say?
I apologize for the time that I took for the report. I do have a 1-year-old and a 4-year-old that's autistic, which I take care of. The mother is not working at the time. I don't do any drugs. Everything I have done is marijuana. I have a marijuana card. The pills that I did have in the card that was in my possession, but I don't take any type of prescription pills, or I don't drink alcohol or anything like that. And I do agree with what you said, the other case about violence, so I just want to let you know.
Well, that's nice to know, but why would you have possession of something if you don't use it? Why would you have possession of opiates that were not prescribed to you, that you reported you obtained from another individual? Why would somebody acquire something? You have to take your hat off, please, sir. Why would somebody acquire something and have it in their possession if you're not going to use it?
At the time, Your Honor, there was the person that was fixing on the car that wasn't mine. It was a new car. When I was dropping the car off, I was taking everything out of the car, and I did put them in my pocket. The person who prescribed me had a prescription for them, And at the time, I did have an ruptured eardrum thing, they wouldn't prescribe me anything.
So you were just gonna self-diagnose?
Yeah, they only gave me some antibiotic drops, so that was in about the pain. Never got a chance to take. I didn't even know exactly what they were, so I didn't have any intention on like having look or not. But I haven't taken any type of other medication in years.
So you drive out to Ann Arbor every day?
Yes, sir. I work for a nonprofit in Ann Arbor. Recently, I've been there about 10, 12 years, 10 to 11 years. Drive about 40 minutes from Trenton to Ann Arbor.
And are you primarily, you still have, but you still reside, correct me if I'm wrong, with the mother of your children?
Yes, we've been together about 15 years.
Okay, so does she work?
She was working for,
I didn't ask you.
oh, no, not right now, she's not working. We have a 1-year-old that she's taking care of, full-time, and so she's not working.
You gonna straighten out your life here?
I thought I had. I haven't been in trouble in a few years, so I ain't been. I don't think.
But then you tried to evade the police, right?
No, actually,
You didn't try to evade the police? You told me at the time of the, hang on, I asked you what the basis for the resist and obstruct was. You said you didn't stop when you knew they were trying to pull you over. Do you want me to go listen to the tape?
no, you're not there.
Well, is that what happened or is that not what happened? I'm not trying to trick you. I just don't want you to come up here sounding like a choir boy when you tried to evade the police. They could have charged you and should have charged you with fleeing and eluding. You got it? Can we agree to that? I don't want him just to tell me he agrees if he doesn't agree. I'm not trying to trick anybody here. That's not what my purpose is. I just want to have a discussion with you and try to figure out why I think that you're going to do better. And I can't say I see a lot of reasons on that right now. All right, counsel, what else? Anything else that you want to say? I mean, if I'm missing something, feel free to tell me, Judge. I don't think you're looking at this right.
So Your Honor, that night, it was dark outside. Mr. Johnson did see police. I don't think it was an intentional invasion at first. It was he thought they were behind somebody else, but it was dark and you got all these police lights behind you. So once he realized it, which was a mile or so later, he did pull over. But it wasn't an initial, I'm gonna run from the police.
Well, at some point he had that mindset. Is that true or false? If it's false, then I shouldn't have never have taken the plea. Right?
It was a situation, again, Judge, it was dark. You got all these.
I know, but I'm just asking you, if he wants to withdraw his plea because he doesn't think he did anything wrong, I thought at the time he told me he drove when the police were following him, and I'm not trying to, listen, I'll let you withdraw your plea right now if you want. If I made a mistake by accepting a plea that I shouldn't have accepted, I'm gonna let you withdraw your plea.
Yeah.
I thought you told me at the time of the plea because I couldn't understand the basis for the resist and obstruct because you didn't provide me any in the beginning. Was that you knew the police were coming after you and you continued to drive. Did you tell me that or not? I'm just asking you, did you tell me that or not? I know how I do things and I know I don't take pleas when there's not a factual basis. I know I don't do that. If I do, I've made a mistake. And if I've made a mistake, I'm going to rectify that mistake and allow you to withdraw your plea right now. And I'm serious about that. In fact, I'll let you go talk to him about that. I'll be glad to do that because I don't want to take a plea from anybody to anything that's a criminal charge of any kind if they didn't commit the act. And I thought that's what he told me. If I misunderstood, it's my fault. I'll accept responsibility. I'll let him withdraw his plea. We can go back to square one. And you can go back and negotiate with the prosecutor. But I thought I heard him say that. If he didn't say that, then that's my fault.
Well, Jim, I think what he said was he knew they were behind him and he should have pulled over. I guess even just to be sure that they were behind him.
Can I speak, Your Honor?
I don't want you to say anything right now without talking to your lawyer. Would you talk to your lawyer first and make sure that we think that you're guilty of that offense? Because if I misunderstood what he said to me, I do not want to go forward with the sentencing on the RNO. And in fact, if he's not guilty of that, maybe the prosecutor can reevaluate, decide she wants to dismiss that case. I don't know. But I'm not going to take pleas and then have somebody come in at sentence and tell me something different than what I thought they said. So if he said something that I misunderstood, my fault, I take responsibility, and you guys can go back and talk to the prosecutor. But I think you should talk to your lawyer before you say another thing, okay? And again, so you got two charges, and if he doesn't feel like he's guilty of the RNO, I don't want to plea. Okay? Thanks. Raymond Lawrence, winner the second, 26B150596.
Good morning, Your Honor. Deanne Fitzgerald, 82378 on behalf of Mr. Winter.
Raymond Lawrence, one for the second.
Good morning, sir. This charge here is a malicious destruction of property and you're requesting a bench trial, is that right?
Correct.
You have the constitutional right to a jury trial, sir. If jury trial, 6 people would be impaneled, all 6 would have to agree that you are guilty beyond a reasonable doubt in order for you to be convicted. By waiving your right to a jury trial, I will be the one who will solely decide your guilt or innocence. Do you understand?
Yes, sir.
You wish to waive your right to a jury trial?
Yes.
Anybody in the world force you to do that?
No.
I'll accept the waiver. We'll set it for bench. What do you have for me, Heather?
Judge, do you want to do this bench trial on one of our Wednesdays or one of our Thursday Brownstown days? Or do we
Probably
need to
on
do it when Miss
Thursday.
Patillo's here?
Ms. Patil's here on Thursdays?
I don't know if she has any Thursdays with us.
No, I don't. I have some Wednesdays, no Thursdays, and 33rd.
Can I get you to come in on a Thursday or do you not have?
It depends on the date.
How about how do I look on the 16th, Heather?
Let me, we,
Wow. Or is that,
I'm on another court.
how about on the 30th?
we don't have Brownstown on the 30th.
I don't have Brownstown on the 30th?
No, we have them on the 16th.
I thought I had them every 2
Or at
weeks.
I don't have them on our docket for the 30th.
And the one Thursday a month, yeah, Brown.
I see. How about, what do I have on the first Thursday in August? Can I do it then or not?
We actually don't have them until August 20th.
I'm sorry, Heather, I didn't hear you.
We don't have them till August 20th in August.
I can do August 20th. Are you available?
Yeah, actually, I am.
I'm here that day, right?
Yes, you are, Judge.
I'll do August the 20th. August the 20th at what time, Heather?
Since it's a bench, do you want to do it at 11?
Sure. 11 a.m. on August the 20th, okay? So, sir, you'll go down the hall, we'll give you your notice and see you on August the 20th. Any questions? Anything else on that, Ms. Patillo?
No,
Do you want those files back on the other one, or you want to just go talk to them? Thank you. Okay, Lillian J. Star Trotter, 26B150733A and B. Good morning, counsel. How are you?
I'm doing well, Judge. Kenneth Camilleri on behalf of Lillian Trotter, Your Honor, who's sitting to my right.
Okay, I'm getting a little, can you get that device a little closer to you? Ma'am, tell me your name, please.
Lillian Trotter?
All right, just keep your voices up nice and loud if you would. I don't know, it's not coming through as strong as it usually does. So I have a plea agreement here that says that the defendant is going to plead guilty to the added count, lesser included offense, I should say, of operating while visibly impaired. The super drunk or high BAC charge will be dismissed. Also, that the defendant is going to plead responsible on count 2 to an amended charge of distracted driving. And the prosecutor then is going to move to dismiss the open intox. Is that right?
That is a correct statement, Your Honor.
Ma'am, is that what you would like to do?
Yes, Judge.
If you plead guilty to operating while impaired, here are the possible penalties. Up to $300 fines, 93 days jail, 360 hours community service, court costs, or all those, 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. If you plead to distracted driving, that's a 0-point civil infraction. You understand that? It won't get reported. Do you understand that?
Yes, Judge.
And then I'm going to dismiss the open intox and the super drunk. You understand that?
Yes, Judge.
I want you to understand that you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the constitutional right to a trial by jury. You could subpoena your own witnesses. You could testify or remain silent. If you remain silent, the fact finder would be instructed that they could not hold that silence against you. If you plead guilty, you're giving up all those rights. You're giving up the presumption of innocence. You're waiving the requirement that the people prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, Judge.
You fully understand everything.
Yes, Judge.
To the charge operating while visibly impaired, ma'am, how do you plead?
Guilty.
Were you operating a motor vehicle on West Jefferson near Campo in Brownstown, May 2nd of 26 at 2:30 in the morning?
Yes, Judge.
Prior to that, did you drink alcohol? And if so, what did you drink and how much? Nice and loud for me.
Yes, Judge. I had about 8 bush lights.
And was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes, Judge.
In what way? Why were you pulled over by the police?
I hit a curb and wrecked my truck.
I'm sorry.
She stated she hit a curb, Your Honor.
You hit a curb when you were driving?
Correct, Judge.
Is that right, ma'am?
Yes, Judge.
Was there an accident then?
There was a one-car accident, her car, Judge.
What did you drive into then, ma'am?
The median. In
A what?
The
Median in the road, Judge. There's a new median on West Jefferson.
All right, so you drove into the median and then the police came to the scene?
yes.
And were you administered a breathalyzer test at the police station or was this a blood draw?
Blood draw, Judge.
Blood?
Yes, Judge.
And do you stipulate that the reading of 0.205 was an accurate reading for purposes of the plea?
The defense would stipulate, Judge.
I'm sorry, I don't know why I'm having a hard time.
Yes, Judge.
Are you on probation or parole right now, Ms. Trotter?
No.
Anybody force you to plead guilty?
No.
Into the charge of distracted driving, you plead responsible or not responsible?
Responsible.
Plea is accepted to distracted. Plea is accepted. I find it to be an accurate plea, operating while impaired. I'm going to go ahead and dismiss the super drunk charge on motion of the prosecutor as well as the open intoxicants on motion of the prosecutor. I'm going to refer you for a screening and assessment. They're only requesting 168. I give 2 1/4 on the blood draw, but if that's the extent of their bill, that's what they're going to get. We're going to have a screening and assessment. You're going to have to come up here, fill out a questionnaire and be interviewed. Has she been going to AA and did she show you proof of that?
I have seen the sheets, Judge. Yes, she's attending as required under her bond conditions.
All right. I didn't realize the breathalyzer, I don't think, was this high. It's pretty high. I'll still keep it at once a week, but I need full compliance. Do you understand that?
Yes, Judge.
All right, so let's get a sentencing date for you, Mr. Camilleri. What do you have for me, Heather?
July 15th at 8:30.
Is that good with you?
Yes.
Yes, Judge.
All right, we'll do July 15th at 8:30. I'm deferring the sentencing on the distracted. I'll sentence you at that time, but I do need you to come up to the court and meet with probation and fill out your questionnaire and be interviewed. Okay, ma'am?
Yes, sir.
You seem very respectful. This is a lot of alcohol. We're going to make sure you don't have a drinking problem, okay? And take care of that, all right?
Yes, sir.
Good luck to you. Thanks, Mr. Camilleri. Have a good day.
Have a good weekend, Judge.
You too. Thank you. Angela Ardith, Rice Day, 26B 838-848, and B and C. Where I got this one. Your name? Ma'am, you're charged with Animal Vicious Act, And you also have 2 civil infractions, dog at large and no license on the dog. You have the right to an attorney. If you want one, I will give you one. Would you like an attorney? All right, I'm going to provide you with an attorney, and you can go out in the hall and we'll set you up and we'll go from there. Okay, thank you. Do I have Scott, Terrell Dwight Scott, 26W842-496, 26W842-665.
Good morning, Your
Good
Honor.
morning.
Crawford representing Mr. Scott. Mr. Scott, please state your name for the record.
Terrell Dwight Scott.
This is, okay, so what are we doing here? This says he's going to plead guilty to stalking on file 2496. That's offense date June 25th. They're going to dismiss, if he pleads to that, the trespassing charge on file 26W842-665. That's a different offense date. That was April 26th. But it also says here, defendant has 2 new trespassing cases scheduled for July 13. Somebody wrote down, let us know if you want us to pull them. Who, is that your handwriting, Heather?
It was mine, and it was directed to Mr. Crawford, or the attorney.
Oh, I see. So I'm just gonna go ahead with these 2 now, and then we'll go from there. If you plead guilty to stalking, they've only charged you under local ordinance. It is punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that, sir?
Yes, sir.
If you plead guilty to that, the prosecutor is going to ask me to dismiss, and I will dismiss 26W842-665, that trespassing charge. I will also tell you that the possible penalties on this are up to $500 fines, 90 days jail, court costs, or all of those. Do you understand that, sir?
Yes, sir.
Now, you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. And you have the right to a trial. At a trial, you have the right to remain silent. You have the right to question their witnesses. You have the right to bring in your own witnesses. You have the right to use the subpoena powers of the court to bring in your own witnesses. If you choose not to testify, that
Oh, yeah, no,
silence
that's
would not
fine.
be held
At least
against
it's
you at a
out there.
trial. If you plead guilty, you're waiving your right to a trial of any kind. You're also waiving the presumption of innocence and the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all of that?
Yes, sir.
All right. Do you have any questions before I ask how you plead?
No, sir.
On June 25 of 20, first of all, to the charge of stalking, how do you plead?
Guilty.
Hang on a second. You act like you're bored.
No, sir.
You're bored. Is this what you want to do?
Yes, I'll take it. Yes, sir.
Don't act like you're doing anybody any favors. This is important. If you don't
Yes,
want to
sir.
plead guilty, just tell me. We'll stop the process now. If you do, tell me that. Do you want to plead guilty or not?
I plead
To the charge of stalking, how do you plead?
guilty.
Were you at or near 25338 Oxford Street in Woodhaven, June 25 of 26 at 3:22 in the morning?
Yes.
And were you at the property of an individual by the name of Christine Weisend?
Yes.
Okay. What did you do that makes you guilty of the offense of stalking?
Knocked on the door.
Crawford? Did he do anything else besides knock on the door at 3 o'clock in the morning? He had to, or they shouldn't have charged stalking.
Your Honor, my client showed up at the residence in question after being warned and trespassed several times in the past, and he defiantly showed up at his home and knocked on the doors throughout the night with the knowledge that he was not welcome there by the alleged victim.
And the alleged victim was not alleged victim or victim Christine Weisend, right?
That is true.
Yes. Okay. Had Christine Weisend advised you on multiple occasions not to go back to her residence?
I believe you have, yes. I believe so, yes, sir.
Your Honor, to assist my client, I might remind him that the police also told him that he could not return to this property several times in the past. Isn't that
Mr.
true,
Scott,
sir?
if you don't want to plead guilty, we'll set it for trial. I'm not gonna ask you a bunch of questions here. You're gonna tell me yes or no. Did she tell you or did she not tell you on multiple occasions not to go back to her residence?
Yes.
On how many occasions did she tell you not to go back to her residence?
I'm not sure. A few times.
What's a few mean? 10?
About 3.
And did the police also tell you not to go back to her residence?
Yes.
Had you previously dated her? What was the relationship here?
Yes.
So she broke off the relationship. Is that fair?
Can you repeat that? I can't hear you.
Did she break off the relationship?
I think the evictions broke off the relationship, not so much as she or I did.
She tell you that she did not want you to go back to the residence.
Not due to the relationship issues. It was more to the fact more of I guess me being evicted from her property or something like that.
Your Honor, if I could assist the court, the alleged victim filed for eviction against my client.
Is that true?
Yes, sir.
So she filed, you guys lived together for a while, right?
Yes.
The property was in her name, correct?
As far as what I seen on the paper, I guess so.
And then she filed a notice to evict you, a 30-day notice to evict you from the property. Is that true?
Yes, sir.
Were you evicted from the property by a judge of this court?
Yes, sir.
Is that in front of me or Judge Hessen?
You, I believe.
Okay. And after that occurred, did you continue to go back and contact her or appear at her residence?
Yes.
Did she tell you not to come back on several occasions?
Yes.
Did the police tell you not to come back on several occasions?
Yes.
And did you then knock at her door at 3:00 in the morning after you'd been warned by her repeatedly not to go back, and after the police had told you on June 25th, specifically at 3:22 in the morning?
Yes.
Probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Is it fair to say that she told you she didn't want you to go back because she wanted to and evicted you because she wanted to not have a relationship with you anymore?
Those wasn't the exact words, but I guess it's not fair that I still went.
What's the exact words?
I can't hear you, sir.
What were the exact words?
Um,
I'm feeling like a dentist again, Mr. Crawford. What were the exact words? Why did she tell you she wanted to evict you?
I never really got, well, as far as what the paper says, it said that I was a nuisance to her pregnancy. A nuisance to her pregnancy. I was, I guess you want to say sexually harassing her verbally.
Okay. Why'd you make me sit here and ask you questions for 7 minutes? Please, are you on probation or parole right now?
No, sir.
Anybody force you to plead guilty?
No, sir.
Something troubled me here, Mr. Crawford. I see the bond I set. I don't usually do that. But I'm going to order a pre-sentence report. I'm accepting that plea. I'm dismissing the trespass. I'm going to order, again, you're not to be released until fitted with a GPS tether. You're not to be within 2 miles of her residence or place of employment. You have to be on that tether. You're not to possess firearms or weapons. You're not to enter or go anywhere near 25338 Oxford and Woodhaven. No contact with prosecution witnesses. No contact with the victim. If I find out you're having any contact with her of any kind, whether from there or otherwise, either by text, voicemail, email, letter, contacting her through people or showing up at or near her residence or place of employment, I'm going to give you a maximum here, sir. Do we understand one another?
Yes, sir.
All right, trespass is dismissed. Bonds continued. We're going to give you an early sentencing date, and I'll look into this. When can I sentence him, Heather?
We could do We could do July 13th at 1 o'clock.
Good enough. Is that good with you, Mr. Crawford?
Oh,
It
you
is,
know
right?
what? Yeah, I would say we have to, is Mr. Crawford here that day or could he zoom in for the sentencing?
At 1 o'clock, I could zoom in. I'm not here otherwise. I am here
Okay.
on the 14th.
Heather, cancel any bond conditions that are not common. Well, I guess they all are, but you're going to take them out on the trespass. We're keeping them on the stalking charge. The trespass is now dismissed. That's what
Okay.
we'll do. July 13th at 1. I wish you well. Good luck. We'll see you then, sir. Stay away from that lady. And if there are more trespass charges, I certainly hope that they are not coming in front of me if they involve this victim after, especially after an order that I gave. That's all I'll say about it. Are they, Heather? Do you know?
Sorry, Judge, my one earbud went out. I switched. What was that?
I just want to know if you know whether or not the new trespassing cases involve him contacting her.
I do not know on that, Judge. I can pull them and look real quick if you'd like me to.
They are your cases and they are scheduled for the 13th. That's today's coming back in place.
Why don't you stay right there, Mr. Crawford? You stay right there. Bring those files down here, please.
Okay, you want them down? Okay, I'll
do.
pull them right now.
I'll go on to another case in the interim. Salvatore Gabriel D'Amato, 26B83910A, B, and C.
Good morning, Judge and staff. John Graziani, bringing on behalf of Salvatore D'Amato. Please step to the podium, sir. To my left, please identify yourself, sir. Salvatore Gabriel D'Amato.
All right, good morning. Counsel, I need to know, first of all, does he stand mute and wave formally?
Yes, he does.
What kind of a dog is this allegedly?
It's a female German Shepherd that weighs, I believe, approximately 72 pounds.
Does Mr. D'Amato have a fenced-in yard?
He does, sir, and everything has been taken care of. This is an unfortunate incident that, in my opinion, has been blown up in proportion. There's, any touching that was done, do nudged, but nonetheless, he's willing to take care of any vet bills, but nonetheless, we, waive the formal rating and stand mute.
Not guilty plea is entered?
We could determine for Judge.
Yeah, I'm gonna give him a personal bond of $500. It says dog on dog attack. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. Defendant's dog, do you have more than one, sir?
No, sir.
It must be in your house. It must be in your house, in a fenced-in area, or on a leash, accompanied by defendant, and equipped with a muzzle. Do you understand that, sir?
Yes, sir.
So otherwise, you're not taking the dog out of your house or the backyard. Do you understand that?
Yes, sir.
All right, we're gonna give you those.
My eyeglasses are messing with my hearing aids.
No problem. Do you understand everything I said?
The last part kind of cut out on me.
Your dog must be in your house, in a fenced-in yard,
Yes.
or on a leash, accompanied by you and equipped with a muzzle. Do you understand that?
I do, sir.
Okay. And you're not to have any contact with prosecution witnesses. I'll give you a new pretrial date, Mr. Graziani. What do you have for me, Heather?
July 15th at 10 o'clock.
July 15th at 10 a.m. in the morning will be the court date. July 15th at 10 a.m. and you can go down the hall and get your paper notice. And I'm entering pleas of denial on the civil infraction charge.
Okay, thank you so much, Judge.
Thank you.
Thank you, Your Honor.
All right. Peebler, Kyle Stephen Peebler, 26B83859A, B and C. Did you have a lawyer, sir?
Yeah.
Okay, your name?
Kyle Stephen Mueller, yeah.
So this says on the bottom, prosecutor moves to dismiss vicious act as defendant voluntarily euthanized the dog. Prosecutor spoke to victim and was advised that defendant paid all related expenses and she does not wish to make a statement. So they're gonna go ahead and dismiss. I'm sorry about your dog. I really am. And I'm gonna go ahead and dismiss that vicious act. And then, as I understand it, you are going to plead responsible to one count of dog at large with the understanding that the no license and the vicious act dog charge will be dismissed. Is that right? Can you pull that out and tell me what our fines, the dog at large things are, please? All right, to the charge, dog at large, responsible or not responsible?
Responsible. Yeah.
Judge, it's 135.
I thought so. I'll accept the plea. Fines cost of 135. I'm dismissing pursuant to stipulation on motion of the prosecutor, both the no license charge as well as the vicious act charge, okay?
That's right.
So you can go down the hall, take care of the fines, 135, and you're all set. Best of luck to you, sir. Thank you.
There's also files on Scott.
All right. Mr. Crawford, can you hear me?
Yes, Your Honor.
I can bring him to you, these to you. These happened after? You better look at these.
I'll come grab the file, Your Honor.
Got Giles, Daniel Curtis Giles.
Yep.
25T646053A. Your name, sir?
Daniel Giles.
All right. You have to pay 200 monthly starting July 1. You're here for time to pay. When can you start paying?
If I could get just a few more months.
Well, I got to get going on this or we're not going to have time to finish it. Where are you working?
I'm not at work yet. I'm still going through physical therapy for my knee.
All right, I got 12 months probation. We started in February, March, April, May, and July. I can start your time I can extend it, allowing you to, you begin on August the 1st, okay?
Okay.
Can you do that?
Yep.
August 1, all right?
All right.
If you need more time, come talk to me, but you're gonna end up having your probation extended if we can't, if you can't pay during the probationary term, all right?
Okay.
Good luck to you.
All right. Thank you.
Zach, Mr. Crawford's looking for those files.
I put him on his desk. He's not
Okay,
there.
he just came in here. Zachary Michael Bowl, 26I-415-321, defendant failed to appear and is responsible as charged by default. Responsible as charged by default. All right. People against Reed, David, Demetrius, Minor Reed, 26I-000-1691 and 1692. Good morning, counsel.
Good morning, Your Honor. May it please the Honorable Court, Darnell Barton, P 83363, on behalf of Mr. David Minor Reed. Sir, can you state your name and phone for the record?
David Minor Reed.
All right, so for purposes of arraignment, first of all, he has two charges here. Let me just double check. It looks like a super drunk and they alternatively charged OWI. Is that what happened?
That is correct. Your Honor.
And now he stands mute, waits for formal reading on both of those. And then as I understand it now, he's going to plead guilty. I'll just put it on count 2, operating while visibly impaired, with the understanding that the OWI will be dismissed and the super drunk will be dismissed. Is that correct?
That is correct.
Is that what you want to do, Mr. Minor Reed?
Yes, Your Honor.
If you plead guilty to operating while impaired, did he execute an advice of rights form today?
I thought they gave you another different. I'll have them fill it.
Here.
I'm sorry, we haven't filled it.
All right,
My apologies.
that's okay. Just have your, who's that? Your associate or your boss?
He is my boss. So if I may, this is Garrett Washington. He's I'm with the Young Lawyers section of the State Bar, and we're doing a program called Journey to Attorney. So we're helping young folks.
Nice.
I want to get to.
Are you a lawyer now?
Not yet. He just.
You took the bar?
Not yet. He just graduated Oakland University, so
Oh, so you gotta go to law
he's
school.
going to the bar. Yep. We have a high school
Well,
graduate,
that's fantastic.
two that are taking the bar in July.
That's fantastic.
We're hanging in there.
Mr. Minor Reed, just relax. I just am having a conversation here. I hope you didn't take you out to what's this restitution, gross yield, $670?
Yeah, that was,
What's that for?
my understanding was negotiated with the cost that was associated with getting Mr. Meyer, but again, I would.
Call him Mr. Wayne. Sir, if you plead guilty to operating while impaired, the possible penalties are as follows. Up to $300 fines, 93 days jail, 360 hours community service, court costs are all 4 points. License suspension or revocation in accordance with your record, and your vehicle could be, or might have to be immobilized depending upon your record. You understand that?
Yes, Your Honor.
Did you sign any advice or rights?
Yes, Your Honor.
Did you read it and understand it?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
Yes, Your Honor.
Any questions before I ask how you proceed?
No, Your Honor.
To the charge of operating while impaired, how do you plead?
Yes, Your Honor.
Were you operating a motor vehicle in the township of Grosse Ile on January 10th of 2026?
Yes, Your Honor.
And prior to that, did you drink alcohol? And if so, what did you drink and how much?
I believe I had 2 or 3 Jack and Cokes.
What else?
That was it. And then maybe no more than 5. No more than 5 Jack and Cokes.
Okay, you said 2 to 3, and then you said no more than 5.
Yes.
So was it 5 or was it 2?
2 or 3.
It was 5, wasn't it?
It was 2 or 3.
So with the judge of
I'm just asking how much you had to consume. Just relax.
It's okay. What the judge is asking, I think he's saying 5. What the judge is asking is how many drinks you have. If you're not sure, you're saying it was less than 5, or are you saying it was only 2 to 3? The judge wants to know. So I
And you want to be honest with the
yes,
judge.
I'm gonna be.
Some people walk in here a lot to tell you the truth and they're not honest.
Yeah.
And we can read through them.
Yes.
So just tell me how many drinks you had.
I had 2.
You had 2 Jack and Cokes.
Yes.
Was this at a bar?
Yes.
So you're saying you only had 2 shots of alcohol?
But you were drinking more. The judge is asking, and I know you're nervous.
Don't be nervous.
Very true. Judge is saying not just those drinks. What did you have that entire time? So you had a Jack and Coke, you had some beer, you had a White Claw, whatever it is, let me know so that we can, one, be on the same page, share with
I've had 3 Jack and Cokes and I had 3 White Claws.
Okay.
I
It
mean,
wasn't so hard, was it?
for that BAC, that 2 Jack and Coke does not make sense.
Why were you pulled over by the police?
Believe I
What do you think you did wrong? Forget what they think. I want to know what you think you did wrong.
first of all, came behind the wheel.
I know, but why were you pulled over? You were speeding, weaving, swerving, what
He was
happened?
on the side, he actually pulled over for safety on the side of the road. He was, the officers came up as he was already inside.
Where were you on the side of the road? What street?
I can't remember, Your Honor. I was following my GPS on my way home.
All right, so you pulled over on the side of the road and the officers approached your vehicle?
Yeah.
And did you feel intoxicated at that time?
No, Your Honor.
You didn't? This is a super drunk charge now. Be careful with me. Okay, come on, just tell me the truth.
Yes, Your Honor.
No, I don't want you to lie to me either. I don't want you to guess. This isn't Jeopardy. Stop, listen to me. Just answer my questions truthfully, okay? Your appearance.
Good morning, Your Honor. Matthew Wayne on behalf of the Township of Grosse Ile.
Good morning to you, Mr. Wayne.
Thank you.
So after you had 3 White Claws and 3 Jack and Cokes, you're driving in Grosse Ile Township, right?
Yes, Your
What bar were you at?
Honor. I can't remember, Your Honor.
Was it on Grosse Ile?
I believe so.
You don't know?
Oh, I was just following my GPS, Your Honor.
Were you drinking by yourself or with someone?
I was by myself. I was leaving Captain James.
In Wyandotte?
No, Captain James is in Gibraltar.
And you ended up on Grosse Ile?
Sorry, I just
Okay,
was following my GPS.
okay, and it took you on to Grosse Ile, right?
I believe so.
And-
Oh, I'm sorry. Yes, Your Honor.
And you pulled over because you were kind of feeling at that point that you were lost. Is that true or false?
That's true, Your Honor.
And then the police approached your vehicle, right?
Yes, Your Honor.
And they had put you through field sobriety tests, is that right?
Yes, Your Honor.
And then did they administer a PBT on the road to you, a machine, portable machine?
If I may, they did initially and then didn't register, and then I believe he refused the second time and they tried. So then they did a blood draw, and that's how.
Is that right?
Correct, Your
And
Honor.
counsel, what were the results of the blood draw?
I believe it was 0.2. I don't have the exact number, for Your Honor, but we would stipulate to what the session.
3.26, Your Honor, I believe.
I'm sorry?
I believe it's 0.26.
That's correct.
All right.
So stipulate.
And you stipulate that was an accurate read. Counsel, one thing I'm gonna ask that they do, and I'm not criticizing, I'm gonna come back to you here in a second. Not you. On these complaints, I need more information. There's no indication what road he was on. You got BAC of 0.17 or higher. There's no indication what street he was on. There's no indication of what it's just a form. And it really needs to be filled in, these blanks. These officers need to fill these in. They don't have what road he was on. They don't have what his blood or blood or intoxilizer results were. I don't look at police reports. It's inappropriate. Are you on probation or parole right now?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Now, how much did you really? You didn't have just three Jack and Cokes and 3 White Claws and get the 2-6. How much did you really drink?
I've had 5 Jack Cokes, a couple of shots, and a couple of White Claws. 3 White Claws.
What kind of shots?
I believe they were, honestly, Jameson.
Okay. Once, tell me about that before. You're not gonna be one of these guys lying to me, are you?
No.
Because a lot of them do. Like, I get the feeling it's either the way I look, talk, or act, that most people don't think I'm very intelligent. And I just ask people to be honest with me. You weren't very honest with me. And I don't appreciate that, okay? You made a big mistake. That's really high breathalyzer. You're over 3 times the legal limit. I'm gonna accept you're not on probation or parole, you said, correct?
Okay.
Nobody's forced you to plead guilty?
No.
I'll accept your plea to operating while impaired, dismiss the super drunk, dismiss the OWI, and putting the plea on file 692. I'm ordering a screening and assessment. I'm gonna set a bond. The only issue I have here is, how are you guys coming up with $670 in foster recovery?
Yeah, of course, Your Honor.
Yeah, but let me see. I can tell you that for decades here, you can hand it right to my reporter. I can tell you for decades here now, I've been capping the breathalyzers at 150 and the blood draws at 2 1/4. Now, maybe I need to revisit that, but I'm not going to order $670. I mean,
Yeah, I would just submit, I mean, I understand that,
it's got $670. He's going to get fined and assessed costs, and I don't appreciate him not being truthful with me. He seems like a real nice kid, to be honest with you. I mean, I've seen a lot worse, but,
I mean, with respect on it, but I mean, aside from the defendant's demeanor, I mean, these are just the figures that the township provided. I mean, I believe they provided in honesty. And these are the rates, Your Honor, and that's what my client has. And I understand that of course, the court is well within its rights to depart from that, but that's,
yeah.
to answer your question, Your Honor.
No, Mr. Wayne, I'm not picking on you. I'm just telling you that I get it. I'm just telling you that I'm not gonna order. Let me ask you a question. You had 3 officers that had spent overtime on the arrest? They were all overtime? Don't answer that. I mean, that's a lot. 3 officers, that's a lot. I mean, so tell them that, I'm not giving more than 2 1/4. And I'm not condoning his.
In this courtroom hearing, Judge McNally is faced with a young defendant who pleaded guilty to driving while impaired by drugs and leaving the scene of a property damage accident. Although the defense attorney explains that the defendant has found a new job and is trying to become a better father, the judge isn't convinced that a few recent changes erase a long history of poor decisions. As the hearing continues, the judge carefully reviews the defendant's criminal record and points out several past offenses, along with an outstanding probation violation. While the defendant insists that becoming a father changed his life, the judge questions why so many legal problems continued afterward. Instead of accepting excuses, Judge McNally focuses on personal responsibility and accountability. The turning point comes when the judge discovers that the defendant failed to fully comply with the court's earlier orders, including attending the required recovery meetings. That immediately changes the outcome. The judge makes it clear that court orders are not optional and that ignoring them has real consequences. In the end, the defendant receives probation with strict conditions, several days in jail, financial penalties, and mandatory substance abuse treatment. Judge McNally closes the hearing with a powerful message, telling the young man that it's time to grow up, leave his criminal lifestyle behind, and start acting like a responsible adult before he loses every opportunity he has left. In this courtroom hearing, Judge McNally is faced with a young defendant who pleaded guilty to driving while impaired by drugs and leaving the scene of a property damage accident. Although the defense attorney explains that the defendant has found a new job and is trying to become a better father, the judge isn't convinced that a few recent changes erase a long history of poor decisions. As the hearing continues, the judge carefully reviews the defendant's criminal record and points out several past offenses, along with an outstanding probation violation. While the defendant insists that becoming a father changed his life, the judge questions why so many legal problems continued afterward. Instead of accepting excuses, Judge McNally focuses on personal responsibility and accountability. The turning point comes when the judge discovers that the defendant failed to fully comply with the court's earlier orders, including attending the required recovery meetings. That immediately changes the outcome. The judge makes it clear that court orders are not optional and that ignoring them has real consequences. In the end, the defendant receives probation with strict conditions, several days in jail, financial penalties, and mandatory substance abuse treatment. Judge McNally closes the hearing with a powerful message, telling the young man that it's time to grow up, leave his criminal lifestyle behind, and start acting like a responsible adult before he loses every opportunity he has left.